You swear affirm the testimony you're about to give the committee will be the truth, the whole truth, and nothing but the truth.
I do.
For our members and our listeners, would you tell us your full name and your affiliation, please?
My name is Scott Wyndham. I'm an attorney in Harrisville, that's in Ritchie County, West Virginia, and I represent oil and gas owners, surface owners, and small oil and gas producers.
Mr. Wyndham, welcome to the Senate Judiciary Committee. We're delighted to have you here. I think you had brought some material you wanted to share with members of the committee. Is that correct?
That's correct, Mr. Chairman.
Right.
I have brought a handout of 3 different documents.
All right, so that is being distributed now. Go ahead, please.
Thank you, and while I'm under oath, I just want to say, go Mountaineers, beat Irish. So,
While you're under oath, do you know the score?
I do not.
What is it?
Thank you,
Let me say it again on the mic.
I'm sorry. So sorry. It's the Fighting Losing Irish of Notre Dame 35 and the West Virginia Mountaineers 42 at halftime.
All right, very good. Mr. I know you are. Mr. Wyndham, go ahead.
Thank you very much. And I'm here today because I have been in opposition to forced pooling in its various iterations through the last 2 or 3 legislative sessions. And what we have in this current bill, 576, is forced pooling in the form of joint development, as well as forced leasing in the form of co-tenancy. So we really are dealing with 2 different things, and I'd like to address both of those. But first, just a little bit of historical background. In Ritchie County, where I live and where I'm from, we don't have coal. We're in a geographical odd region, or geologically odd region of West Virginia, where the coal is about 1 foot thick and it's 800 feet deep. So we have been an oil and gas producing county for well over 100 years. My great-grandfathers on both sides of my family were in oil and gas. We have, because of that, severed oil and gas from the 1800s in places in Ritchie County, and have dealt with fractionalized ownership. I understand and appreciate what the industry needs to do in terms of co-tenancy. I don't believe that this bill does the owners of the oil and gas justice, but I understand the need. I'm not necessarily opposed to some form of a co-tenancy bill if it has proper constitutional protections, which I don't believe this bill does, and I will explain that. The old leases in my part of West Virginia had a flat rate, and that was usually $300 per year per well. Later, those wells were drilled on a 1/8 royalty, and this body, by a statute in the 1980s, said any new wells drilled on a flat rate lease would have a 1/8 royalty as well. So that 1/8 royalty has been in place now for about 80 years, depending on if it was a flat rate lease or not, or a negotiated lease. So today's leases that I negotiate with Antero, JB, try to negotiate with EQT, we are looking at royalties depending, if you're in Tyler County, you may have a royalty of 20%. If you're in Doddridge County, that may be 18%. Ritchie County could be 16 to 18%. Significantly higher than a 12.5% royalty. And when you're talking about a well that makes millions of cubic feet a day, I have clients that come in with monthly checks of 6 figures. It's a significant amount of money for my clients. So I know that my clients who own fractionalized ownership would like to have their minerals developed. But in the handout that I gave to you all, the first document there is an EQT check to one of my clients. And I've highlighted some numbers. And if you look over on the right-hand column, there are some negative numbers. I don't know how it's possible to have a negative royalty, but for 2 months in 2016, my client actually owed EQT for taking her oil and gas to market. She had a negative royalty. They didn't pay her, or they couldn't pay her. They didn't charge her for those 2 months. Instead, they waited 4 months until she had a positive balance. And over the term of the 4 months, she had a revenue of $128. This is an old flat rate lease which was converted to 1/8. They took out $117.23. Her check was $10.82. She lost nearly 92% of her income. This same company then comes to my client and asks for a modification of another oil and gas lease. She's 85 years old. She says, yes, I'll modify, but I want to talk about these terms. EQT says, no, we're not going to do it. They sued her in circuit court to take her minerals from her. That's not right. Today's oil and gas leases have left us in a situation where you have unequal bargaining power and you have informed and uninformed oil and gas owners. The uninformed oil and gas owner will sign a net proceeds lease. They will not worry about the shut-in royalty. They don't ask for the Pew clause, which Mr. McMahon talked about yesterday. And actually, there are two Pew clauses, a vertical and a horizontal. They don't ask for various surface concessions. They don't ask for royalty, shut-in royalty, gross proceeds, those types of things. So if you have one informed, educated oil and gas owner who owns fractionalized ownership of 25% of a tract, under this bill, that one person who knows the modern terms and who knows what a lease should contain is going to be stuck. They're going to be stuck with what the uninformed oil and gas owner signs. Because once they get 66.6%, they don't have to negotiate those better terms anymore. Now, this woman owns small fractional interests, and she holds out for good terms. And if you look at the two leases that I have attached behind her check, those are two form leases from Antero Natural Resources and EQT. The Antero lease, the EQT lease has a clause that is contained on page 3, paragraph 8. It says, governing law jurisdiction. The jurisdiction for any dispute or claim under this agreement shall be the United States District Court for the Western District of Pennsylvania or the Common Pleas Court of Allegheny County, Pennsylvania. Why would this legislative body require someone to go to Pennsylvania to dispute royalty payments? This legislation does not modify the terms of the lease for the 66% who are uninformed. This legislation would require the informed oil and gas owner who doesn't sign the lease, who's in the minority, to go to Allegheny County because they would be stuck with the bad lease. There's also an arbitration clause, voluntarily giving up her Seventh Amendment right to a jury trial. She wouldn't voluntarily give that up, but this legislation would compel her to give up that Seventh Amendment right and go to arbitration if 66.6% of the other owners wanted arbitration. Now, the legislation does not address or need not address the unknown, missing, and abandoning heirs. There's a statute, West Virginia Code 5512A1 et seq, that deals with the missing, unknown, and abandoning heirs. That's not a concession by Wavonga or anybody else in the oil and gas business to put the unknown, missing, and abandoning heirs in this statute. That's not a concession. That is corporate greed, because it takes away the due process. It takes away the right of those unknown, missing, and abandoning heirs to have a guardian ad litem appointed in circuit court to represent their interests. What it does is it speeds up the process, because that statute has a 6-month waiting period that Wavonga's members do not want to wait. They want to speed things through and get them done at the expense of an oil and gas owner who may see their grandfather's name in the paper or their grandmother's name and say, hey, maybe I own this oil and gas. That's happened. I have represented unknown, missing, and abandoning heirs in Ritchie and Doddridge County who have come forward. So to put the unknown, missing, and abandoning heirs in this statute is wrong. There's already a statute to cover that. It is not necessary, and that will get them to their threshold if they follow the due process already provided in that statute. Now, Senator Woelfel mentioned yesterday that if he and Senator Klein owned a business with Senator Romano and they decided to sell to Ms. Ojeda, that would be a similar type situation. And you weren't far off, but the difference would be if you owned a widget business making small, medium, and large widgets, and you agreed to sell to Ms. Ojeda, but she decided she would only pay you and not pay Mr. Romano and hold that for 10 years without paying Mr. Romano. Well, maybe she only wants the medium widgets. She can then sell the small and large widgets to somebody else and take her profit and still keep Mr. Romano from being paid for 10 years. Because these leases, the Antero lease has a 5-year primary term with a 5-year extension. That means that the person holding the oil and gas in that remaining portion that wasn't leased, the minority interest, would be held for 10 years without Antero having to deal with them, without Antero having to pay them. They would be stuck. And that's where the difference is, because Ms. Ojeda can make her profit, you all would get your upfront money, Mr. Romano's sitting there for 10 years waiting to see what happens. So the due process, I believe, needs to be included in this bill, and that would be for the oil and gas terms, this 4- and 5-page lease that you have in front of you, to be determined by a group of land commissioners, similar to what you have in a condemnation case right now. That would allow for an appeal, the due process right of an appeal to circuit court, and would allow for the circuit judge to make a determination whether or not the lease terms are reasonable. Currently, under the unknown heirs petition, that's what's done. There is a determination by the court that the guardian ad litem and the company have worked out the terms of the lease and they're acceptable. In addition, it would cut down the partition suits, which are currently ongoing in these matters, and the court would not be burdened with any more cases than what they already have with the partition suits and ongoing unknown, missing, and abandoning heirs. Thank you.
Thank you, Mr. Wyndham, for the information. We have questions. I think some lights popping on. Let me ask a question. So in the course of this process, one of the things that I think I've learned is that under our current law, West Virginia is a bit of an anomaly in that a person who owns a fractional interest, no matter how small, can prevent his co-tenants or co-partners or co-owners from proceeding with development.
That's correct.
And do I understand, is it your position that our law should remain that way, or are you saying that there needs to be some, let me ask it this way, is there a number, a threshold, a percentage at which you think it's fair or reasonable for a majority or a supermajority to drive the bus on those questions, so to speak?
I think that 75 to 80% would be a reasonable number, with the 20 or 25% having their due process in circuit court to lease those unleased minerals at that point in time. I do understand that the industry needs to get those minerals leased, but I don't think that 66.6% is a fair number. I think that it needs to be 75 or 80%.
Okay. But you are at least, and you're a person that has apparently a good bit of experience in the area of the law, willing to consider some process by which West Virginia moves more toward the mainstream on the co-tenancy question.
That's correct.
Okay. Thank you. Senator from Montague, you have a question for our guest.
Thank you, Mr. Chairman. And Mr. Wyndham, thank you for being with us. I truly appreciated your comments, and we'll have EQT up here in a little bit, I hope, to respond to some of this. No, my comment is to the chairman. Mr. Chairman, I would like a printed copy of the comments from the gentleman from Ritchie County. If we could have that provided to us by Monday, it would be greatly appreciated.
I'll check with staff. I don't think there'd be a problem with transcribing it.
Thank you.
You're talking about Mr. Wyndham. Okay.
Thank you. Thank you, Mr. Wyndham.
I won't promise Monday. It will depend on staff, but we'll definitely try to do that. Okay, Senator from Wood County, have a question.
Thank you, Mr. Chairman. Just a quick question. What is the mainstream number in terms of co-tenancy in other states? What do most states have? What percentage?
I don't know the answer to that. I'm only licensed in West Virginia. I haven't researched that issue.
Okay. Just curious, what the number you said was 70, 75%? You
75 or 80.
75 or 80. Is there a reason you like those numbers? What is it just seems fair? Or?
Well,
Not trying to put you on the spot. I'm just curious your rationale for those numbers.
sure. The 80% number came from the prior legislation and dealings with my former delegate, Woody Ireland, and what he had
That
done
came from the polling bill from 2 years ago?
the stakeholders meeting that occurred 2 years ago. That's correct.
Yeah, okay.
Yep.
Thank you. Thank you, Mr. Chairman.
But you would recognize and agree there is a significant difference between this bill and that bill, in that this bill would not, in its current form, force in someone who owned all of his minerals and didn't want to be in.
That's correct. It would only force in those minority interests in this particular bill. I do understand that, yes.
And you know, okay. Senator from Wetzel has a question.
Thank you, Mr. Chairman. Scott, thank you for coming down. I know you've made at least 2 trips down here from Ritchie County, and that's not always a pleasant trip, so thank you for coming.
It was worse going back last night than it was coming down.
Question for you on the 2 leases. How much of that lease from either Antero or EQT was negotiable?
The Antero lease, depending on whether or not the individual owns the surface, we add between 8 and sometimes 14 or 15 different clauses in an addendum that we negotiate with Antero. The EQT lease, I have a tough time negotiating with EQT, but their addendums that I work out or I try to work out are sometimes close to 40 different paragraphs. So.
Well, is the arbitration clause, we're sending all this to Pennsylvania, was that negotiable?
That was.
They would negotiate on that?
They will negotiate on that if you negotiate with them for that, yes.
Okay.
They will remove that from the lease.
Both EQT and Antero?
Antero does not have the arbitration or forum selection clause in their lease, just Antero at this time, or I'm sorry, just EQT at this time.
Okay, thank you.
Mr. Wyndham, just as a follow-up, is it your position that the legislature should, in some statute, prohibit people from negotiating a forum selection clause?
While I personally don't like a forum selection clause, I think that it is patently unfair to require a mineral owner in Clay County to travel to Pennsylvania to negotiate or to argue an oil and gas lease issue. I've personally recently sued EQT in the Circuit Court of Ritchie County for an oil and gas royalty issue. What you have, I've seen a lot of these leases recorded where people don't negotiate that out. And a savvy person who reads the lease and pays attention and knows what that is, knows what that forum selection clause means, will negotiate that out. My fear is, and what this statute would allow, is if you have 2 brothers and a sister, and the brothers decide they're going to go ahead and lease, and the sister looks at it and says, I don't want to go to Pennsylvania, she's going to be out of luck because the brothers told her, basically by signing this lease, you're going to Pennsylvania if there's a dispute. And the lease terms, the 20 paragraphs in the Antero lease and 22 paragraphs in the Antero lease and the several enumerated paragraphs in the EQT lease, the statute only deals with royalty and how it's to be calculated. It doesn't say that all the other lease terms have to be determined. So as I read the statute as an oil and gas lawyer, if I have a client come in or read the bill and they come in and they say, you know, my 2 brothers just signed this lease and now EQT won't deal with me, I'm going to say you're going to Pennsylvania because those lease terms are going to be stuck for her as well.
Okay, thank you. Any other questions for Mr. Wyndham? Senator from Greenbrier.
You may have answered this while I was out getting water, but it may even be an unfair question, but you've been through all of this from the beginning, not just this time, but last time and time before. How does this bill compare to what you've seen before? Better or worse sometimes?
Well, it's better and worse. The 66% is certainly worse.
Right.
the fact that you can use the surface if you get 2/3 of the surface to agree is worse, because the former bills did not have surface use unless the surface owners all agreed to it. So, you know, I wasn't happy with the prior bills, and I'm not happy with this one. I think that the due process rights and surface owner protections need to be there, but more importantly, the fact that it is forced leasing, the fact that you're forcing someone to take a contract to sell their oil, gas, and minerals is really problematic. That without that due process right, much as you have in an eminent domain proceeding, that's really a hang-up for me.
And I was keeping score. That was 2 worses, if there is such a word.
I got you.
Thank you.
Any other questions from members of the committee for our guest? If not, Mr. Wyndham, thank you very much for your appearance here today and traveling down from Ritchie County.
Thank you very
and
much.
We'll look forward to maybe having you back before the committee.